Good morning, guys. Can you hear me?
Yes, I can.
We will, just a calendar note, we will not have a live session tomorrow. We probably will on Thursday morning, unless at the end of this morning I say otherwise. And so I'm expecting that we will meet live on Thursday, finish Chapter 5, and then probably pick up again, and then I'll post over the weekend as to what our schedule will be next week. Last time we left off just getting ready to talk about the Little Rock Nine. These were 9 African American high school students who attended Little Rock, Arkansas High School in 1957. They were only able to after President Eisenhower called out and nationalized the Guard in order to protect them so that they could exercise their constitutional right of going to a public high school that was not segregated. And yesterday on National Public Radio, I listened to a story that was from about that same time, and I put up, it's from National Public Radio yesterday, and the link is on the slide, and if you copy it down, you can access the audio. It's about 5 minutes long. It's an interview with a young woman. You probably have heard of Rosa Parks, the young woman who refused to give up her seat on the Montgomery, Alabama bus, even though the law at the time in Montgomery, Alabama was that blacks had to sit only in the back of the bus and had to relinquish their seat to whites. And there were two, at least from my point of view, at least two interesting things about this story. Keep in mind that that the young woman, who is now, of course, in her later 70s, did this when she was 15 years old. She refused to give up her seat and was arrested by local police and sent to jail. Two interesting things, at least. One is that she described the fear that her family experienced and the ostracism that her family experienced after she was arrested. And it was an interesting commentary and description on her part. She said that the night she was released from jail, her father sat up all night holding his shotgun in their house because they were afraid for their lives. She also indicated that many of her black acquaintances and the parents of her black acquaintances and friends distanced themselves from her and her family because they were afraid of being associated with her or her family in some way, and that they felt many members of the black community felt endangered as a consequence of her action in 1954. The other interesting, and that reinforces the evidence that the New York Times recently published regarding the weekly occurrence of lynchings over a 73-year period in the southern states. The other thing that was interesting is that she was not part of the, what she termed, black elite in Montgomery, Alabama, and so while she and her family thought about filing suit because she felt that her constitutional rights were being violated, ultimately lawyers did not file a suit, but they did when Rosa Parks did the same thing some months later. And Rosa Parks being from a more respected, quote-unquote, respected black family in the city. And the thing that's interesting about this, and that reinforces a point that I've made in earlier classes, is the whole issue of forum shopping. What do we mean by this? Well, we talked about this in the context of federalism. Political actors, whether they're government officials, interest groups, businesses, what have you, political parties, look for a favorable venue to get that's more likely to lead to the policy outcome that they want. The same is also true for quote-unquote potential litigants. What I mean by that is the black community leaders in Montgomery at the time felt that she was perhaps not the best candidate to file suit, being, among other things, a teenager and not from one of the better families, quote-unquote, in the city. And that therefore they waited till Rosa Parks did precisely the same thing, and then the suit was filed. And so, and this is not uncommon, it goes on today as well, that those who wish to challenge a law in the courts don't just do so willy-nilly, but they try to put together the best case and the best, quote-unquote, best people that they can in order to pursue their legal and policy goals. And so, but it's an interesting interview, and they also interviewed her attorneys at the time. So last time we talked about, I just ended talking about desegregation of the Little Rock High School in 1957. I thought it would be useful to look at where those people are now and what they've done with their lives, the 9 African-American students. And here they are, and you can see one became an Assistant Secretary of Housing and Urban Affairs under President Carter. He was also a managing partner at Lehman Brothers. Another was a career Army, made the Army, U.S. Army a career. She was also a journalist and a part-time social worker. Another was an accountant for the U.S. Department of Defense. The third earned a doctoral degree and teaches at UCLA as a clinical psychologist. Another graduated from Michigan State and is in the real estate industry. Another woman moved to Canada where she's a writer and social worker. Another woman received a graduate degree in Sweden and has been a prolific computer science writer and magazine publisher. Still lives in Europe. Another one was a teacher after she graduated from college. And another was an author and former journalist for People magazine and NBC. So these people became, somehow made it through this traumatic experience and became quite successful and contributing members of our society. I'm going to try, if I can, to move to another page and share it with you so you can see some images. If not, I'll come back to the slides. Do you see something besides the slides?
Yeah, we see your, just change. Let's see. Blank right now.
Speak up so I can hear. Do you see this web page?
Yes.
It is loading.
Okay, let me know when it's loaded. So is this visible to you guys or not?
Yeah, it just looks like it's scrolling. Yes, it's good now.
Can't hear. Okay. So this was the governor at the time. There are the students. That's the governor there. This is when the students first tried to enter Central High in Little Rock. They were denied, and this was some of the crowd behind them that was not very friendly. This was the National Guard turning away the 8 of the students from school. This is the National Guard guarding the school so that there would be no outbreak of violence once they were, at the time. And eventually, this is, again, part of the crowd that was protesting the integration of the high school. President then nationalized the National Guard, and then the Guard escorted the students into school. This is one of the permits that circulated around the high school, permits in quotes, and these are some of the students. Now let's see if I can get back to the slideshow. Okay, I did it. How about that? Okay, so we need to talk about the Civil Rights Movement. The Civil Rights Movement did not just start in the late 50s or the 60s. This was a long time coming. We talked about President Truman's action in 1948, but there were leading African Americans. One of the most important, Philip Randolph, was working quietly, lobbying, talking to political leaders. There were many African Americans who were doing this. It didn't just start in the late 50s. Nonetheless, Martin Luther King became a prominent leader of the civil rights movement in the 50s and 60s. There were others as well: Malcolm X, the Student Nonviolent Coordinating Committee, CORE, and the Black Panthers. So this was a diverse movement for civil rights, and sometimes quote-unquote black power at the time, to try to get full civil rights, voting rights for African Americans at the time. And so we spoke last time about the passage of the Civil Rights Act of 1964 after the longest filibuster in American political history. The act expanded voter registration. It provided access for everybody to public accommodations, again, restaurants, hotels, buses, etc., to public schools. It outlawed discrimination in employment on the basis of race, religion, and gender. In 1965, the Voting Rights Act was passed, and this enabled the Justice Department to, based on the disparity between the number of African Americans in a county and the number of African American voters, to go into individual counties where there was clear and compelling evidence that African Americans were denied the right to vote. In 1968, the Civil Rights Act of that year was passed, and that outlawed discrimination in housing. One of the things you just need to keep in mind, it's one thing for Congress to pass a law. It's one thing for the president to sign a piece of legislation. It's one thing for a federal court to make a ruling. But that doesn't mean that it happens automatically as though one waves a magic wand. Because ultimately, the executive branch of the federal government and the executive branch of state and local governments have to enforce the law. And they are constrained by budget considerations, by all kinds of things that we'll talk about later. If there's no, for example, last week our country came within a couple hours of shutting down the Department of Homeland Security. At the end, just before that was to occur, that Congress passed a 1-week extension of its budget. That also ends this week. And so it's just a matter of a couple days before the Department of Homeland Security, is shut down again, unless Congress and the President act. And so in that is a kind of a poster child, a good example of how and why it is the government sometimes doesn't actually do what it says, what the law says. Because ultimately, somebody has to enforce the law, and that somebody has to be paid. And if services aren't provided, one of the main reasons is because there's no funding for it. So what are the consequences of the civil rights legislation passed in the 1960s? They are measurable. First, black voter registration and voting increased. Second, black and minority access to higher education increased dramatically. The political participation and election of black local and state officials increased. One of the consequences was the expansion of a relatively small black middle class. Another result was that there was a new emphasis on rights and their extension, not just to black people, but to women, the anti-war movement, gay rights, and the environmental movement. Yet at the same time, there was continuing resistance to civil rights, and lingering social and economic disparities remained powerful, and they're still measurable, and we'll talk about that for a moment in a bit. So again, civil rights, as I suggested at the beginning of our discussion of this chapter, are not self-enforcing. They're not automatically enforced. Both require positive actions of state and federal agencies consistent with federal law, and in the absence of such action, civil rights will tend to be a source of social and political conflict rather than government policy. Just to give you one example, with respect to Brown v. Board. Brown v. Board ruled unanimously that school districts were supposed to be desegregated with all deliberate speed. Two things. One, who created the segregated school districts in the first place? Who drew those boundaries? Local school boards. Who was legally responsible for ending that practice? Local school boards. So if you've done something for 40 or 50 or 60 or 80 or 100 years, and some federal judge or court comes along and says, oh, you can't do that anymore, you can keep doing what you've been doing all along until somebody makes you stop and do something else. But if you choose not to obey the law, not to obey the court's ruling, then further legal action has to be taken. And if nobody objects, then the same practices continue. Secondly, part of that resistance to school integration, especially in the South, was the creation of private academies. Well, federal government says, the courts say we have to integrate public schools. No problemo. We won't send our children to public schools. And many white households and families said exactly that. And what they did instead was they created private academies, largely white-only schools, and sent their kids there. In other words, they have, under the law, people can choose to set up a private school if they just do it on the basis of race. At the time, there was nothing illegal about so doing. And so there are always ways to try to get around a government program or a government service or a government decision. They may be eventually prohibited, but there are ways that those with resources can deploy in order to try to avoid the consequences of federal law. Every so often in the news you hear about millionaires and billionaires moving their money, and companies sending their money overseas to Swiss bank accounts and so on. That's another example. Don't want to pay taxes? Fine. I'm going to put my money in a Swiss bank account or in an island in the Caribbean where I won't be taxed. So one of the things that's important to keep in mind is it would seem that a lot of these things happened many years ago, decades ago, and that everything should be okay. People have equal rights. People can vote more or less. People can buy homes, buy cars, avoid being discriminated against in employment. But take a look at this research done by the Pew Research Center, which is a highly regarded and respected foundation. So on the left, you see that in 1983, during the Reagan administration, the median net worth of white households compared to black households was 10 to 1. In other words, the net worth of whites was 10 times the net worth of African American households. In 2013, that's now 13 to 1. In other words, the inequality in a period of 30 years has grown by 30%. Similarly, if you look at the wealth gap between whites and Hispanics, what was 10 to 1 in 1983 has continued to be 10 to 1, with slightly more than 10 to 1. So there's no diminution of economic inequality for Hispanics during this 30-year time frame, and a 30% increase plus or minus for African Americans. So whatever formal legal benefits the civil rights movement helped establish into law, it's not the case that it's made any difference in terms of the economic status of blacks as a whole in our country. Comments at this point before we move on to women's issues? Anything? Okay, thank you. So historically, there's been a linkage between civil rights movements for African Americans and women's and movements for women's rights. The movement for women's rights started almost 170 years ago, and actually even earlier than that. Two of the leaders were Elizabeth Cady Stanton and Susan B. Anthony. And in the 19th century, the abolitionist movement and the women's movement were intertwined to some degree. And in the 20th century, the civil rights movement began to become a visible piece of the American political landscape. And shortly after that, the women's movement took off. Women's struggle for equal rights was first recognized nationally in the passage of the 19th Amendment in 1920, not quite 100 years ago, and as a consequence, women were given the right to vote in national elections. In some few states, women did have a right to vote in local and state issues, but that depended on the state. Actually, I saw something yesterday in the news that there's an effort in Vermont to lower the voting age in that state to 15 or 16, so that high school students would be able to vote. The women's struggle for equal rights began to take off in part as a consequence of the publishing of some important books, the establishment of major women's organizations in 1966, like the National Organization for Women, and the passage of Title IX of the Education Amendments of 1972. The key language here is at the bottom of the slide: no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So what this law said was any educational institution that receives government aid or assistance in any manner, that would be, for example, receiving money for research or receiving money for student loans, they would need to comply with this provision, Title IX of the 1972 law. Again, there were a number of employment-related laws that were passed beginning in 1963. The Equal Pay Act, Title VII of the Civil Rights Act of '64, which bars sexual harassment, wage discrimination, and employment discrimination. Again, though, it's important to keep in mind, the courts don't go out, and I'm going to repeat this when we talk about the federal courts. The job of a court and the job of federal judges is not to wake up in the morning and look to see where and how and who violates federal law. That's not the way our system works. The way our system works is, okay, there's a law. If you feel you're being discriminated against in employment as a woman, say, and you can document it, and you can document the harm and the injury that you've suffered as a consequence of your boss's or your company's illegal behavior, you have to get a lawyer, usually pay the lawyer, file suit, and wait for the legal process to work its way forward. And that takes a lot of time. And so if one has very limited resources, if one's living paycheck to paycheck, and one wants to keep one's job, that makes it pretty difficult for people. So again, these laws are not self-enforcing. Somebody has to go to court to claim that they've been damaged, or somebody's got to organize politically an interest group to pressure either agencies or legislative bodies to change the law or enforce the law. So in the 1970s, Congress passed by a 2/3 vote what was called the Equal Rights Amendment. And ultimately that amendment was not approved by 3/4 of the states. The states that did not approve the Equal Rights Amendment are listed on the final bullet on this slide. And they are all northern states with the exception of Illinois, southern states with the exception of Illinois and Nevada and Utah being the 2 western states. Oklahoma is you could say it's western or it's southern, but it's one of the 2 or 3 most conservative political states in the country. And so what did the amendment say? What was the constitutional amendment effort put forth by those who supported equal rights for women? Well, it's right there. It's very short. Section 1, 2, and 3. Equality of rights under the law shall not be denied or abridged by either the U.S. government or any state government on account of sex. Congress shall have the power to enforce that provision, and the amendment shall take effect 2 years after the date of ratification. Well, it was never ratified. So, in point of fact, the legislatures in these states, 15 of them roughly, came out against the idea of a constitutional amendment providing equal rights for women. And again, this may seem to your class as though it's not too controversial. You might look at one another and say, what's going on here? What this shows is, looking back at it, one of the things it shows is how difficult it is to actually pass a constitutional amendment. Well, the women's movement has had some political outcomes. One is that there's been a significant increase in the number of women running for office, both in national and state elections, and there's been a significant increase in the number of women winning elective office. Women now constitute about 1/5 of the Congress, and this is more than triple than 25 years ago, but women are only about 10% of all state governors. Nonetheless, that is, while these percentages seem low, they're much higher than they were, say, 40 or 50 years ago. Under the current administration, a number of things have been done to try to address the issue of women's rights. Keep in mind that the President of the United States can only do so much with respect to executive orders, and normally for most major legislative changes, you need Congress to pass a law. Well, the first law under the Obama administration was the Lilly Ledbetter Fair Pay Act. And in fact, you're going to have a writing assignment that deals with the history of that act. And it was designed, again, to fight pay discrimination, and you're going to end up doing the research on that law. The Obama administration also created the Equal Pay Task Force to give women more tools to fight pay discrimination. It also ended the ban on government aid for international groups that provide abortion information and stopped Republican efforts in Congress to defund Planned Parenthood. Parenthetically, you might ask, what do women's rights and foreign policy have to do with one another? And there's one very visible, absolutely ironclad difference between the two parties. When a Democratic president is elected, the president, very shortly after taking office, makes sure that the Department of State and other State Department agencies are involved in providing family planning services to women around the world, which might include would include information about abortion and contraception. When a Republican president is elected, that stops within the first week of the Republican taking office. It's happened over the last 20 years in exactly that way. One of the, without getting into the substance of the issue, pro or con, reasonable people, it seems to me, should be able to agree that making public policy on a starting-stopping basis, 4 years it's one thing, 4 years it's exactly the opposite, 4 years it's the opposite of that, 4 years it's the opposite of that, that makes no sense. I mean, whatever. It is a nuts way to make foreign policy. Women's rights are also important under the terms of the Affordable Care Act. Prior to the passage of quote-unquote Obamacare or the Affordable Care Act, insurance companies discriminated against women. They made women pay as much as 150% more than health insurance than men. Under the Affordable Care Act, the health insurance plans cover women's preventive services, well woman visits, mammograms, birth control pills, though religious-oriented businesses and groups have been trying to prevent that, screenings without co-pays or deductibles, and as you're probably aware, there's still litigation in the federal courts now trying to overturn the Affordable Care Act, though its constitutionality has been, as a law that includes a tax, has been upheld by the Supreme Court. But there are more challenges yet. Again, the Obama administration and women's rights. First time in American history, all of President Obama's appointments to the Supreme Court have been women, including the first Latina ever appointed to the Supreme Court. The Obama administration created the White House Council on Women and Girls to support fair treatment in matters of public policy. It increased funding to enforce the Violence Against Women Act and to protect victims of domestic violence and reduce violence against women. 3 women cabinet members and women headed the Office of Management and Budget, which is arguably the most important domestic policy agency. Also, women head the Environmental Protection Agency, and a woman is the U.S. representative at the United Nations. I mistyped this. One measure of progress over, say, 30 years is that during President Reagan's 8 years, there were a total of 3 women cabinet members. Over President Obama's 6 years, 7 women were cabinet members, and 1 confirmation of the new Attorney General is pending a United States Senate vote. So women have been and remain important national political figures. In the Congress, probably the most visible woman is the former Speaker of the House and now Minority Leader Nancy Pelosi. Also, the head of the Democratic National Committee is a woman. The front-running Democrat for the presidential nomination in 2016, Hillary Clinton, of course, is a woman. And probably, I was trying to think of this morning, probably the best-known Republican woman nationally is Sarah Palin, former vice presidential candidate with Senator McCain, but she doesn't hold office currently. There's been a lot of talk over the recent years about whether or not there is a war on women, quote unquote, and different media pundits will say one thing or another. So I thought it might be useful just to get away from the media stuff and just look at what state legislatures do and have done. So in 2011, the state legislatures introduced over 1,100 provisions related to women's health and reproductive rights. And in the first quarter of 2012, introduced another 944. So that's 2,000 legislative provisions, many of which were the same, over a period of about 15 months. Half were designed to restrict access to abortion. Legislation is also focused on what are called mandatory ultrasounds and narrowing the time when abortions may be performed and limiting or eliminating insurance coverage of abortion. Over an 11-year period, state legislatures have enacted 135 laws designed to limit women's reproductive rights. This is, in part, a response to Roe v. Wade, which did the decision in the 1970s that does allow the states, and subsequent decisions, the Webster decision, which do allow states to not eliminate abortion constitutionally, but to regulate it in various manners. Some of these provisions obviously have been challenged and overturned in the federal courts, others have not. In 2013, 2 states banned abortion outright in clear violation of prior Supreme Court rulings. 9 banned abortion after 20 weeks, and some made no exception for rape and incest. In several states, it hasn't passed yet, a fetal personhood issue has been placed on the ballot, and these threaten to punish a wide variety of health services for women, including common forms of contraception, in vitro fertilization, and medical treatment of pregnant women, but they have not passed. 10 states, including Indiana, have laws that require a woman to undergo a mandatory ultrasound at her expense before she can obtain an abortion. The laws themselves are not medically necessary, or the procedure is not medically necessary, and it is in fact a physically invasive procedure. And it requires doctors to practice medicine in a way that is they might regard as inconsistent both with doctors' sense of best practice and the wishes of a patient. The most recent anti-abortion legislation includes the following efforts. First, banning abortion later in pregnancy, no matter what the woman's particular circumstance is, requiring women to undergo medically unnecessary ultrasounds, attempting to regulate abortion providers out of existence. Texas is a prime example. Mississippi is another. Preventing insurance coverage of abortion and reducing women's benefits, health benefits under insurance, limiting women's access to medication abortion, enacting longer mandatory delay requirements, and enacting selective abortion bans. One of the most respected and accurate and comprehensive private foundations in terms of its ability to describe everything about the healthcare system is the Kaiser Family Foundation. And they've been looking at what state legislatures have been doing in the last few months, and they've been introducing more than 100 new restrictions in terms of access to abortion in more than half the states. And these proposed bills would require women to watch videos before they could proceed with an abortion, continue to ban abortion after 20 weeks, restricting what physicians, medications that prescriptions can prescribe, and bills that would completely outlaw the most common surgical abortion procedure. So state legislatures, it would appear, or at least some of the members of state legislatures, are very much involved in making medical decisions for women around the country, or at least trying to. Social movements for civil rights, human rights, women's rights are normally really important in the protection of civil liberties and civil rights. In the absence of some kind of continuing effort on the part of American citizens, an organized effort to see that civil rights are protected, state and local governments and maybe even the federal government may backslide a bit. You know, again, I'm going to come back to what I suggested earlier. We ask governments, we ask the federal government to do an awful lot. And in the area of civil liberties, we're saying, don't do this, don't do that, restrain yourself, we have rights, we have privacy. And on the other hand, with civil rights, we're saying, you have to be aggressive, equality under the law, you need to stop unfair and illegal discrimination from occurring, especially on the basis of race, ethnicity, religion, and so on. So this is a hard act for any government. I'm going to take about a 30-second break here. I'll be right back. One of the most controversial issues of our time is immigration. And this focuses primarily, though not exclusively, on Latinos. And I will confess flat out, I am totally biased on this issue. I have a very clear opinion, and it's based on my own family's history. Simply put, my grandparents were immigrants. My grandmother was in my great-grandmother's stomach, or in her body, rather, as they came over on the boat to Ellis Island. Both on my mother's side and my father's side, they were immigrants in the late 19th, very late 19th and early 20th century. Had my father's family not come to this country, they would have been ruled by Stalin and perhaps killed by Stalin. He was very good at that. If on my mother's side, if they were not able to leave in what is now the western part of Ukraine, there's every reason to believe that they would have been slaughtered by the Nazis. Simply put, it's highly unlikely I would be here anywhere on the planet were it not for my grandparents' ability to come to this country and to be welcomed to this country. And my family has been very fortunate, and we have been quite successful as a group. And we are very grateful for the opportunities and the freedom that our country has provided several generations. So there is no way, not one way, not even remotely possible, that I'm going to look at other human beings in other parts of the world and say, you can't come here. Because if somebody had said that to my grandparents, I wouldn't be here. I can't do that to people. So that's the personal thing. That's just the way it is, pure and simple. The demographic and political reality is and the policy issue we should talk about as well. If you look at American history, it seems to me pretty clear that one of the major themes, one of the things that makes our country America, is the frequency and significance of immigration and migration patterns. If you can't understand that, then you don't understand the history of our country. You don't understand what it's been and how it got to where it is. This is not a class in sociology. I am not a demographer. I am not a geographer, though I know something about both disciplines. But I know enough to know that almost all of us are immigrants. Probably a lot of us didn't come here legally. And I know enough to know that immigration over time has changed and is changing American society. Obviously, in terms of the lives of immigrants, the question of the availability of work, the accessibility of public services, the freedom to not be incarcerated or returned to your country of origin, the quest to keep one's family together, these are all major issues. But there's also a political significance, a social and a political significance to the whole immigration issue. Demography is always a tricky thing. One of the things we know, for example, is that under the Obama administration, a significant number of immigrants have been returned to their country of origin, more so, I think, than in previous administrations. A significant number continue to be incarcerated, and immigration has slowed in part as a consequence of the economic collapse of 2007, 2008. So one always needs to take demographic projections with a grain of salt, because demographic projections normally are based on data from the past, and the past is not always a very good guide to the future. So Nonetheless, it would seem that sometime in your lives, it would be likely that, in fact, maybe even within 35 or so years, that only a plurality of people in the United States would be Caucasian. Blacks would remain about the same. The Asians would increase significantly, not double over a 40-year period, but maybe up by 70–75%. Hispanics are projected at being 30% of the population in 2050. Demographic change can come pretty rapidly. My father, for example, lives in Arcadia, California, a suburb of Los Angeles. And he's lived there for a little over 40 years. In that period of time, it's gone from a largely Caucasian town to a majority Asian community. My point is not that this is good, bad, or in between. My point is that over the period of a few decades, the population change can be pretty significant. Now, what does this have to do with American national government? And the answer is a lot. These are projections of in the somewhat short term, maybe medium range of the Latino population in selected American states. There are 10 states here. What's important here? What's important in terms of American politics is, and by the way, it should be noted that not all Latinos are the same. Some are from Cuba, some are from other islands in the Caribbean, some are from Central America, some from Mexico, some from South America. So it really is not accurate to say, well, they're all alike because they're all from south of the United States and they all speak Spanish. Well, they don't even all speak Spanish. Okay? In Brazil, they speak Portuguese. The bottom line is this. Look at these 10 states. Which are the 3 states with the largest, 4 states, with the largest number of electoral college votes? You know what they are? California, Texas, Florida, New York. Illinois also has a high number of electoral college votes. Colorado is a very competitive state between the 2 parties. A candidate for president, if a candidate for president wins the election in Texas, California, Florida, and New York, that candidate and that party is well on its way to winning the presidency. And so the fact that there are 20, 30, 40, 20 or 30% or close to 20% of the electorate being Latino means that, you know, Latinos are not concentrated in Delaware. They're not concentrated in Rhode Island or Montana or Wyoming or Alaska. states with very few electoral college votes. You know, if they were all concentrated in those states, their potential political power would be much reduced. But they're not concentrated in those states. They're concentrated in the larger states, states with higher population, much higher population. And so, over time, even though there are relatively few visible Latino political organizations, there's every reason to expect that the Latino vote will become increasingly important in American national government. Comments or questions?
No, now we good.
Okay, so the Americans with Disabilities Act of 1990 was passed in that year. And these are some of the provisions, two of the provisions. The important thing to know here is that a larger and larger percentage of our population is likely to be people or persons with disabilities, in part because of the aging of the population. So if I look at my own family, okay, my father will be 94 in July. My mother-in-law will be 86 in May. These people aren't going to be running marathons anytime soon. And as medical science advances, and as people take better care of themselves, and as they live longer, they will live longer, but they will likely have reduced physical capabilities over time. And obviously there are people who are younger that are going to have disabilities as well. And the question of how we treat them, how our society treats these people. Disabilities can happen to anybody. It can be by birth. You could be in a car accident. It could be old age. Disabilities know no social class, no ethnic group, no religion, and taking care of people, many people with disabilities, is very, very expensive, which is one of the things that Social Security is designed to do, is to help people who have contributed to Social Security over the years, if they become disabled, to provide them some kind of benefit. Another major issue, one that you're going to write about tangentially, is the status of gay males and lesbians. And there has been clearly a social movement which became most visible in the late 1960s with the Stonewall riots in New York City. And that movement has continued and has grown. And homosexuals have sought and worked for and lobbied for and filed lawsuits to try to protect and enhance their rights on the job, their rights as citizens with respect to tax laws and the state laws, their rights with respect to health benefits, and their rights to be safe from violent acts based on discrimination and or hate. So almost 7 years ago, the Congress tried to pass a federal marriage amendment designed to limit marriage to a union of one man and one woman. And that amendment did not pass the Congress with enough votes. And so we see a number of things happening. Yes, there's been a denial of full civil rights for gays. There's been a cultural marginalization of gays. Some political officials say, well, if we allow gay marriage, then we're gonna be eventually permitting sex between human beings and animals. We're going to be allowing bigamy and all other kinds of horrors that will, they think, derive from the legalization of either civil unions or marriage between homosexuals. There's clearly been a social movement. There's clearly been favorable state and federal court rulings. There's clearly been some leadership from presidents initially, and although there's controversy about that leadership, President Clinton, don't ask, don't tell, and so on. One of the major, and there's been changing business practices in major companies with respect to the recognition of benefits for gays who are in, who have partners. One of the most important legal legislative acts was the Defense of Marriage Act, which was passed in 1966, and it was ruled unconstitutional about 2 years ago. And that ruling, holding Section 3 of the Defense of Marriage Act unconstitutional, is an interesting one. I'll describe it to you briefly. A woman named Windsor was married to another woman, and she saw that other woman passed away. And Ms. Windsor sought to claim the federal estate tax exemption for a surviving spouse. In English, what this means is when you're married and your spouse dies, if your spouse leaves all of his or her money to the spouse, it's generally not taxable unless it's in the many, many, many millions of dollars. However, the Defense of Marriage Act, that was again passed in '96, provided that the term spouse only applied to marriages between a man and a woman. So when Windsor tried to claim that exemption, the Internal Revenue Service says, not so fast, Ms. Windsor. That applies only to marriage between a man and a woman and not for those who are in a same-sex marriage. Your claim is denied, and you owe $363,000 in estate taxes. So, Windsor, obviously not too fond of that IRS decision, took the issue up to the Supreme Court and won. And the court held that a portion of the Defense of Marriage Act was unconstitutional, primarily under the Fifth Amendment Due Process Clause. There have also been other factors involved in the granting of more and more rights to homosexuals, a new generation which seems more open-minded with respect to sexual mores, the role of the military, just like the military was important in the movement toward integration in our country, so too the military has been an important piece of the story of extending rights to gay people. And there have been changes in federal policies and regulations as well. Okay, so I'm going to sum up very quickly. Enforcement for all is neither built into American government and culture, nor into many community traditions, and it is not inexpensive. The enforcement of civil liberties and civil rights is expensive, it is difficult. And in fact, all levels of government regularly violate civil liberties around the country, even when there are court decisions and laws that prohibit such actions. Evidence suggests, I believe, that in the absence of consistent federal government enforcement of civil rights laws, which is to say most of the time, we can expect state and local governments and officials around the nation to fail to enforce and even violate civil rights laws. There is not a day goes by that an unarmed black man is shot and killed. And many times it's not a man, it's a teen. And it's not just blacks. And that's just for openers. We can expect many businesses, nonprofits, and persons in our society will routinely seek to deny equal rights to one or another marginalized minority or disadvantaged group. I can't believe how many news articles I've read in the past year about owners of bakeries refusing to make a wedding cake for a gay couple. They're all over the country. Oregon, Indiana, you name it. You can't do that. At least be in compliance with the law. Yet it's up to the people who are harmed to seek redress. The government isn't going to just say, you, like I just did, you can't do that. No. Those people who have been harmed or have been discriminated against have to step forth. Normal bureaucratic behavior. Why are civil liberties and civil rights violated often? I do not agree with those who want to impugn the integrity and motives of everybody else in politics. Normal bureaucratic behavior, inappropriate information and training of officials, community customs and traditions are often plausible explanations of why civil liberties and civil rights are violated. Courts have only some enforcement powers, really not that much. Governments are shut down, budgets are cut back, so government agencies sometimes can't function very effectively. Crisis and gridlock seems to be the mode of the federal government as often as not. And so as a consequence, things don't go quite as we had hoped. So I know you got to go, and we will pick up with the last 2 slides next Monday.
All right, thank you. See you next Monday.